Okay, so late last night, midnight, I think, Blake Lively's attorneys filed her motion for the fees and costs that she was awarded under the 47.1 order that Judge Lyman came out with just a couple weeks ago, I think. And we're going to go over that this morning just a little bit. I'm going to go over it more with Omar later today. So we're not going to look at all of the attachments, all the declarations and stuff like that right now. I'm only doing this on like a quick kind of break from work, so we won't be here too long this morning. But I'm going to go over the actual brief with you guys and also point out some things that are just kind of nonsensical. But my first thought last night when I saw this come up is I had been asked by Sarah, what do you think that she's going to ask for? And my initial thought was Blake Lively's going to ask for something like $1 million, right? And it's only related to the defamation counterclaim that was dismissed. That is all she's awarded this like fee shifting for. So it's like she's probably going to ask for something ridiculous. It's going to be like $1 million, right? But then I thought, wouldn't it be fun if I underestimated this person one last time, the lengths that she's willing to go to? She'll probably ask for $500,000, right? And so this pops up, and I click on it. I'm like, you know what? I'll just look at it real quick before I go to bed. And I thought, I definitely shouldn't talk about this tonight because asking for $8 million for one dismissed counterclaim is insane. This can't be right. But I also don't recall smoking any crack this evening. So I had to sleep it off and just think on it a little bit because I don't think my analysis would have been very insightful at the moment. It would have just been like, is this bitch crazy over and over again for like 45 minutes to an hour? So I thought, better leave this for tomorrow. And here we are. So I will tell you right off the bat, though, one thing that I notice is in this, list of the things they are billing for, a lot of this happens to be after, like pretty long after the Justin Baldoni's case was dismissed based on their motion to dismiss. And they're asking for things that were related to Lively's affirmative claims, her case. Like things related to her deposition here, revising letter regarding her deposition, strategizing, deposition preparation. That was all for her case. She settled her case for nothing, for $0. Okay. And so these fees that she's being awarded are related only to the countersuit. She's not being awarded anything related to her case. She did not get anything in the settlement. They released the entire settlement document. She got no money from that. And so them trying to bill for this stuff just seems kind of insane to me. We also have in this document, they're asking for money for like the spoliation sanctions motion, which they'll mention in the brief that I'll go over with you guys. And that's cute that they wrote that motion, right? But it had nothing to do with Justin Baldoni's counterclaims at all whatsoever. It had everything to do with Blake Lively's lawsuit, which she settled, as I said, for nothing. It was never ruled on. So God knows if they even would have gotten anything they asked for in that motion. So there's just a lot of insane things that they're asking for in this. And they're also trying to say basically that 47.1, they can get fees for the defense of the entire, against the entire countersuit, not just the defamation claim, but that's not actually, in my opinion, what was awarded. So let me just pull up the actual brief here. And we're not going to go through this entire list of things this morning. We'll go over that later. We'll be with Omar later on. I don't know when yet. I'll let you guys know later today, but he'll explain a lot of the legal stuff for us. So I'm not going to get too into the weeds on that. Okay. And this is not like too long of a brief, so that's good. But give me 1 sec real quick. Okay. So Ezra Hudson wrote this, and of course it's a little flowery and poetic, and also full of creative writing. So we'll get to that. But it says, before this litigation began, Steve Sarowitz, the billionaire financier of Wayfair Studios, and Justin Baldoni threatened that if Blake Lively ever crossed the line, he would use his vast personal fortune to destroy Lively and her husband, comparing his plan to a holy war. So what was the line, though? So we're not really representing this truthfully. Ever crossed the line as in crossed him, or or what? Because what he actually says is that he would spend however much money he had to spend to defend his studio against false allegations. So the line is something that you should probably never cross if you're a decent human being. But sure, this paints a pretty picture, I guess. Okay. The Wayfarer parties made good on that threat just days after Lively filed her administrative complaint for sexual harassment and retaliation with the California Civil Rights Department. Claims which they have now admitted were protected activity that deserve to be heard by filing a frivolous, baseless, and retaliatory $400 million defamation lawsuit designed to sue Lively into oblivion. So again, we're misrepresenting exactly what was going on here, because she didn't just file a CCRD complaint. She did all this around the same time, if not at the same time, as she went to the New York Times and blew shit up in public, trying to ruin their reputations. So you have a right to make a complaint if you feel uncomfortable in the workplace, and making a complaint in and of itself is a protected activity. However, going to the press and trying to ruin someone's ruin someone's life with claims that are not actually truthful is not a protected activity. Otherwise, anybody could make a complaint about anything that, like, things that people haven't done. You could just go make a complaint, and that you could use that as, I made a complaint, so now I get to go destroy your reputation in the press. That's not really a thing that we should be encouraging. So they try to make this about the CCRD, but actually they were defending themselves against this public onslaught from her going to the New York Times, from her abusing the courts to take Jen Abel's phone contents through Van Zandt, using what's essentially a shell company, in my opinion, to do that. So again, we're misrepresenting a lot of the facts here, and they have to do that, okay? Because when the judge awards them some of what they're asking for, and he will give them some money, probably not $8 million, right? But he will give them some money, then they can misrepresent what he's saying, as they have previously, and say, the judge agreed with everything we wrote here, that's why he gave us money. And that's not true. But wouldn't be the first time. I remember the last hearing just earlier this month when I was in New York, listening to Mike Gottlieb make arguments in front of the judge. He mischaracterized Judge Lyman's own ruling, and Judge Lyman said, I'm pretty sure I didn't say that. That's not what I said. So, and that wasn't the first time that happened either. So, they'll misrepresent what the judge's ruling means. This is all a PR war at this point. We know that. One sec. Puppy Moose says the judge only allowed reimbursement for charges related to the defamation case, $8 million. That's not legal. I mean, legally, she can ask for whatever she wants. She could ask for a piece of the moon, but she's not entitled to it. That's not a fair compensation, I would be shocked if the judge awarded her $8 million. I think that's insane. And these guys have a week to respond to this, so they can come back and say, hey, this is why this is unreasonable, which should be easy given the way that they laid it out in that chart that I just showed you guys. There's a lot that doesn't even have anything to do with the countersuit, period, let alone the defamation claim. You know what I mean? All right. This gross abuse of the legal system was not meant to win in court. Its aim was to retaliate against Lively by falsely branding her a liar, intimidating witnesses in the media. Honey, you don't want to go there. And discouraging others from speaking out. Now, who tried to subpoena people who were talking about the case to discourage them from speaking out? Which party was that? Which party asked for my location data and my bank account because I was commenting on their public court proceedings in a way they didn't like? Which party was that? I can't remember. Funny they would say anything about abuse of the legal system when they did that, among other things, including the Van Zandt lawsuit, as we know, and then trying to circumvent Justin Baldoni and the Wayfarer party's rights to a jury trial by trying to get the judge to award damages without ever going to a hearing presenting evidence. they pulled some pretty crazy moves. Let's see. This gross abuse of the legal system was not meant to win in court. Now, I could argue that exploiting this California law meant to protect survivors as some sort of branding opportunity for yourself, a tone deaf one at that, and using laws that very obviously did not apply to you was also not a winning strategy in court. But okay. I mean, if we're saying like ill-advised or bad strategies are an abuse because they're not meant to win in court, then I think pot, meat, kettle, you know? Okay. Somebody asked if she exceeded the page count. I think, well, I don't think so, because this starts on page 5, right? And it goes down to page 15. So like, I mean, I don't know if he was really counting this kind of table of contents, table of authorities. Like, I don't really know if that counts to the page limit. I think they're probably fine. But that's just if I had to guess. All right. The Wayfair parties filed first in California state court against the New York Times, withdrew it, refiled in federal court, and then amended for no reason other than seeking publicity designed to impose maximum harm on Lively. Now, it was never ruled that that was the case. This is just, again, flowery storytelling. Then after they vowed in the media that they would amend their complaint following this court's dismissal of their entire complaint, they quietly abandoned their lawsuit. Okay. I think they mean the claims that were dismissed without prejudice. So again, if you want to talk about vowing to do something and changing your mind being like some sort of demonic strategy, then maybe don't take to Instagram vowing to fight for women and girls' safety, as if that has anything to do with your silly movie drama. And then drop your lawsuit for nothing because you know it's not going to go well for you. I think maybe, again, pot, meat, kettle, but that's just me. The Wayfair parties employed scorched earth litigation tactics designed to drain Lively's resources, including a near-daily press campaign promoting their sham lawsuit, propounding expansive and irrelevant discovery demands, obstructing discovery directed at them and affiliated third parties, and forcing Lively to seek frequent relief from the court to rein in their abusive docket filings. Now, again, this is pot, meat, kettle. There's a lot going on here, especially the near-daily press campaign. She blew this up by going to the New York Times, and it's not like she was just sitting there quietly twiddling her thumbs this entire time. She went on talk shows. She gave speeches, basically slandering Justin Baldoni and the Wayfair parties. Like, this is stupid. Her whole complaint about these people is that they defended themselves in the press, essentially, and that they used the litigation privilege the same way that she did. Because she filed the CRD complaints so she could go to the New York Times and have them publish that. They needed some protection, the litigation privilege. And then they use, again, the litigation privilege to get their side of the story out, and they publish that on a website. If that's the strategy you want to go with, don't demonize it when the other person does the same. Okay. The Wayfair parties chose to bring this retaliatory action in this court under California law, despite California Civil Code Section 47.1's robust fee and cost shifting provisions and readily available public information regarding the rates charged by the law firms they knew would defend Lively. Okay, sure. They could have ended it and offered to reimburse Lively at any time. You're right. I guess they could have abandoned their case settling for nothing at any time, even at the 11th hour on the eve of your trial. But that's fine. Having refused to do so, they should be ordered to reimburse Lively for all of the costs, attorney's fees, and expenses they improperly forced her to incur. Now, remember, this 47.1 it applied to attorney's fees and costs related to defending against the defamation counterclaim, not even the entire lawsuit, not the entire countersuit, nothing to do with Lively's case or her affirmative claims, only the defamation claim. But they're going to try to bulldoze right over that. So. Okay. They go into some background here, talking about filing the lawsuit, amending in January, a couple weeks later. An obvious PR tool filed for no conceivable legal reason before any responsive pleading or deadline to amend. The 391 paragraph first amended complaint and 168-page Exhibit A was an unhinged rant that attempted to brand Lively falsely as a liar. Yeah, right. I much prefer my unhinged rants in an Instagram story. But cool. The Wayfarer party sensationalized their lawsuit by launching and promoting a website, thelawsuitinfo.com. Okay, describing the launch of the lawsuitinfo.com, and they're just like citing some documents here. Signal group chat gloating about the website launch. Like, these people are so butthurt. It's insane. And you know, like when you see people online criticizing these publicists the way that you do, the reason that these publicists are getting so much hate is because they were thrust into the spotlight and they're the only publicists involved who have had their personal business thrown out there for everybody to see. And a lot of that was done wrongfully when she used a sham lawsuit to get Jen April's phone. But make no mistake, Lively's publicists are doing and saying a lot of the same exact things. Like some of the most brain dead, rot, crap that I see online is people blaming the publicists and the media contacts that they were forced to disclose in discovery. And they're like, look at these media contacts. We have to read the articles that each individual person is writing for each publication and just know that they're part of a smear campaign. I'm like, bitch, no. Like, that's what publicists do. They have contacts at media outlets. They work those contacts to do good publicity for their clients. You have to be absolutely stupid to think that that is a special service offered only by Justin Baldoni's publicists. What's wrong with you? Use your brain. Kathy asks, does this mean they're breaking their agreement with Wayfair? They agreed to $0 for the case. No, because they agreed to $0 for her case. They stipulated that the 47.1 motion would be something that they could still litigate and that neither party would appeal the judge's ruling. The judge denied her bid for like insane punitive damages and triple damages and all that because that was batshit crazy. But he did say that she could have attorney's fees and costs related to the defamation claim. So this all falls, it doesn't break anything in the settlement. Unless they were awarded money related to stupid shit from long after this claim was dismissed, which they are asking for. I just don't think they're going to get it. All right. Okay. The court determined the Wayfair action live visit from excuse. They consolidated them. Okay. I'm skimming over some of the history because we all know how this went down. As this court acknowledged throughout the litigation, the parties engaged in an extensive and fiercely contested discovery process. So most of the discovery, including all of the depositions and everything, were related to her lawsuit, not theirs. But they're asking to be reimbursed for things related to her lawsuit anyways, which is not part of the deal here. But that's why they've blown up these costs so much. Okay. This required Lively to file over 15 discovery-related motions to compel during the course of these actions. Actually, she wasn't required to do some of that. Some of that she did, and it wasn't necessary. But, I mean, they can kind of argue back and forth as to which ones were necessary and which ones weren't, and which ones she should be reimbursed for. Did they have anything to do with the actual defamation claim? That kind of thing. It'd be met with sanctions. That was the motion to strike on the Taylor Swift thing, I think. At least I'm pretty sure. I'm not going to go look at the docket number, but I've got to think that's what that was because I remember the motion to strike. On March 20th, Lively moved to dismiss the First Amendment complaints. Okay, on June 9th, they dismissed it in its entirety, criticizing it for lacking clarity as to the boundaries of claims and for relying on conclusory and often dramatized allegations. Well, dramatized allegations are part of both sides of this case, but okay. Given the baseless nature of their claims, Lively served 5 of the Wayfair parties with Rule 11 safe harbor letters. Okay, so they're talking about these sanctions motions, which were granted, but the judge denied any sort of monetary reward that they had asked for. Because it did not actually impose any extra burden. He said there were pleading issues, mostly group pleading issues, to where like the Wayfair parties all listed themselves in all of the claims. So where there were contract claims, where somebody like Justin Baldoni or Wayfair Studios could say Blake Lively violated a contract, Melissa Nathan was not part of that contract. So the judge would say there's a group pleading issue. This is technically baseless, right? Because Melissa Nathan didn't have a contract with Blake Lively. So it should have been written differently. It should have been set out differently. You should not have named all of the Wayfair defendants in each one of these causes of action. But, you know, why make that easy to understand when you could just confuse people instead? Okay. It's on September 8th, she did the initial 47.1 motion. On June 12th, the court granted the motion. Yeah, that was a couple weeks ago, finding that Lively made statements that come within the purview of 47.1, prevailed on her defense, and there is no evidence she made her statements with malice. And of course, there couldn't be evidence that she made her statements with malice because this case was dismissed. They didn't get to go through discovery and all that. There was no trial. There was no hearing. So whatever. That doesn't mean that she didn't lie. It doesn't mean that everything she said was true. It just means they don't have any evidence. They didn't produce anything in discovery to show that. And the case was dismissed pretty early on. So that wasn't going to happen. All right. Here we're in the argument. The Wayfair parties are liable for Lively's attorney's fees and costs. Okay. I mean, the judge already ruled on that. We don't really need to read a recap, but accordingly, Lively seeks $8,035,040.88 in fees and costs for her successful litigation defense. Okay, let's think about this for a second. $8 million for defending against a defamation claim in a countersuit that was dismissed over a year ago. And she had all of her case going until a couple weeks before trial. How much do you think it cost her in attorney's fees to cling on to her lawsuit for that long and do an insane amount more work on her case than they had to do in defending against this one, only for her to drop her case right before trial for no money? $0. That's not a great look. So, as reflected in Exhibit B, we're not going to read the declaration until we come back with Omar later because I've got a lot of questions for him. So, this figure represents the expenses incurred in work performed by Lively's counsel, blah, blah, blah. Okay. Specifically, the fees and costs that relate to motion practice associated with the Wayfair action. Okay, including but not limited to the motion to dismiss, the Rule 11, which the judge already declined to award any fees or anything on, and motions to compel. 2, work performed associated with the consolidated action as a whole, including discovery through the deadline for the Wayfair parties to amend their pleading that was relevant to both actions. And 3, Lively's 47.1 motion, including this application. So the 47.1 motion, I can see why they would ask for fees on that. The prevailing motion to dismiss, I can see why they're asking for fees on that. The Rule 11 thing, like I said, the judge already looked at that, gave them the sanction as far as like the reprimand that they were asking for the group pleading issues that Brian Friedman had in that complaint. Number 2 here, work performed associated with the consolidated action as a whole, that's both lawsuits consolidated, including discovery through the deadline for Wayfair parties to amend their pleading that was relevant to both actions. So, again, like this, even if they had amended, which they didn't ultimately, that was over a long, long time ago. The deadline for that was a long time ago. And they're asking for things related to like spoliation sanctions motions and the Lively action. And it's just stupid. Like, why would you ask for that? That has nothing to do with the 47.1 motion or the defamation claim. It wasn't even brought until long after all of this, to my knowledge. And she didn't have to go through discovery related to this because it was thrown out. So after the motion to dismiss was granted, she didn't have to go through any more discovery related to that lawsuit. Yet she's trying to bill for it as part of this attorney's fees and costs award. Right. Section 47.1 does not permit apportionment of defense fees and costs. So it does not limit the recovery of reasonable attorney's fees and costs to the successful defense of a particular claim, i.e. defamation, but instead applies to the successful defense of the litigation. So Section 47.1, and this is something that Omar will have to answer for me. Section 47.1, when it talks about the litigation, it's talking about defending against a defamation lawsuit. So I don't really know how this is going to go. I couldn't tell you that. I'm not a lawyer, so maybe we won't delve into that too much here. Apportionment of Lively's defense costs by claim is not permitted. Section 47.1's conferral of a fee-shifting right to the recovery of fees for successfully defending in the litigation distinguishes 47.1 from other fee-shifting statutes. Under California law, apportionment may be appropriate in other contexts, such as where a plaintiff has prevailed upon some claims but not others, or where a statute textually limits fee shifting to particular claims. Yeah, so this was specifically related to the defamation claim. I don't really see this going their way, but I could be wrong. So all right. Let's see. We'll skim over some of this stuff that I'm going to have questions on for Omar. Let's see. The text and purpose of Section 47.1 do not support the use of apportionment principles here. So they're talking about the difference between Section 47.1 and the regular anti-SLAPP statute, which requires like a special motion to strike. We saw that in the Friedman action with, not Friedman action, actually the Flores estate action against Brian Friedman, where he did a special motion to strike. Yeah, I won't get into the weeds here too much because I think I'm gonna have a lot of questions, and I can't answer them for you guys. So we'll come back when we have somebody who knows what they're talking about. All right. No such concerns apply to Section 47.1, where success is measured by the litigation rather than a specific claim. I will say, like, this sounds like they're nitpicking words a little bit, and I think that the litigation in the language of Section 47.1, the litigation is literally referring to a defamation claim. So, because it only applies to the defamation claim. But, all right. In the Wayfair action, Lively succeeded in every conceivable measure. All of the Wayfair parties' claims, which were brought as a strategy to sue her into oblivion, were dismissed with prejudice and abandoned without amendment or appeal. So the no appeal part of this was part of the settlement, so that's disingenuous. So they know that they didn't appeal. They gave up their right to appeal because Lively wanted that as part of the settlement in allowing her to abandon her case before trial. But all right. In the Wayfair action, Lively succeeded in every conceivable measure. Okay, but what she asked for was fees related to the defamation claim. So. Yeah, we're going to skim over the rest of this apportionment stuff. Lively's attorney's rates are reasonable. I mean, the thing about the attorney's rates being reasonable is I don't know if they were doing like duplicate work. I don't know if all of their work is necessarily related to the things that were awarded, which is related to the defamation claim. I don't know if you necessarily needed 20 lawyers to attend one hearing. That's fucking insane. So there's going to be stuff that they have to challenge the reasonableness of, which I won't get too much into now because, like I said, we're going to go through the attachments like the declarations and the fees that they were asking for, the specific things they were asking for later. But for now, we'll just leave it at that. The reasonableness element here is going to be challenged, I think. They talk about the lodestar method, which again, we'll wait for Omar on that one. Okay. First, the hourly rates charged by counsel are reasonable based on the experience and qualifications of Lively's counsel and standard market rates. Second, the rates are well within the range of rate determinations in other cases. Third, the lodestar billed hours are reasonable. Okay. Finally, even cases dismissed at the motion to dismiss stage may still involve considerable expenses, fees, and other financial and emotional harms stemming from attorney time defending them. I don't think emotional harms were included in the ruling, but you know, again, like, so how would they even account for that? Emotional harms. We all have to reopen this and have like a therapist talk to her and then go to the judge and say, hey, Blake Lively deserves $4 million in her emotional harm or something. Like, I don't even know how that's supposed to work. All right. Well, that's the end of the brief. Like I said, we're going to go over, by the way, it's $7.5 million in attorney's fees and the costs are over $500,000, which is, I thought she was going to ask for like $500,000 to $1 million. This is, I don't know, your crack pipe and smoke it, and you'd probably get the same result writing this motion. I don't know. This was the table that we're going to go over later. If you missed it early on, we took a look at that, but they're asking for stuff related to like depositions and spoliation sanctions and all kinds of crazy shit. Like some of this is down to like February of this year, and it's not to do with the 47.1 motions. Yeah, so review emails regarding spoliation motions. That has nothing to do with the defamation counterclaim. That's nuts. All right. Strategize and prepare for oral argument on spoliation motion. Why should you be given however much money here for that when it has nothing to do with the countersuit that had been dismissed almost a year ago? Like, that's bizarre. All right. I got to get back to work, guys. So that's all I got for this morning. Don't forget to hit the like button for me. It helps me out a lot. I will post here. Let me show you where this will show up. When I have an idea of what time I'll be back with Omar later. So what you can do is you just go to my YouTube channel. If you click on my username under the stream you're watching right now, it should take you here. And you go to the post tab. And then you can see all the posts that I put up. And then if you are a channel member, you can go here and see if you've missed anything that is members only. I have a couple of things here and a post or two that are members only posts. So you can click here, members only posts, that kind of thing. Let me see if I have, I might still have, because it's the 30th, I might still have some free ones to give away. Hold on. Let me check. Yeah, I still have 5 free ones to send for the month, and it's the last day of the month, so I'll do it now. Let's see who gets them. Donnie, Deborah, YSL Cows, Mimi, and Kimberly. Okay, well, you guys got the free membership, so that's cool. So if you just got one of those gifted memberships, you can go to that membership tab and see all the members only stuff that is posted there. So, all right. That's all I got for now, guys. I'll be back later to talk with Omar about this stuff. And then also, if you guys have been following, I had this issue where I had paid Afro Man, who was asking for appearance fees, to do an interview on my channel months ago, right after his court case, and he never followed through with the interview. On a promised date that it would be done by, I got ghosted, and so I asked for a refund. Now, when trying to get the refund, his team was kind of like blowing me off. They're saying, oh, we'll send it tomorrow. Oh, we'll send it tomorrow. Oh, no, there are holds. Oh, my phone broke. I got my phone broke twice. All kinds of crap, just delaying it. So I made a social media post about it, and his manager saw it. And so his manager and Afro Man got in touch with me last week and said, okay, we'll refund you the money. And since then, I still haven't gotten my money back. I sent an invoice to them, a link that makes it really easy, because he said he's only doing PayPal. So I was like, here's a PayPal invoice. Click the button. All you have to do is hit the button to pay me back. And I still haven't got my money back. So we'll talk more about that later. Teresa, one of the attorneys I met at the courthouse in the last hearing in the Lively case, was actually answering a lot of questions for me, and she came up with a guide. So I'll give you guys a link to that as well later for anybody who's running a channel and has any questions about what you should do if you want to interview someone in the future. I would not do any paid interviews, but how that should go with negotiating that. So, all right. Thanks, guys. Appreciate it. And I'll talk to you later. Bye.